Hello everyone, my name is Divya and we are Group 13. Today we will dive into a critical topic of whether Section 97, Subsection 1 of the Child Act 2001 is good law. We will then explore the ways we could go about in strengthening or amending these laws to better protect our children's rights. Firstly, let's quickly break down the Child Act of 2001. What is the purpose of the Child Act? This act consolidates and updates the Malaysian laws on the care and protection and rehabilitation of children. This act reflects Malaysia's commitments to social justice, ethical development, and economic progress, ensuring protection for all children and emphasizing the family's role in nurturing their growth and well-being. But how old must one be to be considered a child? Under the Child Act of 2001, a child is defined as a person under the age of 18 years old. So what exactly does Section 97, subsection 1 say? It states that a sentence of death shall not be pronounced or recorded against the person convicted of an offence if it appears to the court that at the time when an offence was committed, he was a child. So what does this mean in layman's terms? To simply put, it means that if someone had committed a crime when he was just a child, he cannot be sentenced to death. In this video, we will explore whether Section 97, subsection 1 is effective and just. We will examine its underlying principles and practical implications, considering how it has been applied in the judicial system. We will also discuss the potential gaps and challenges in its implementation and look at ways to strengthen this law to ensure that it better serves the interest of children and society. So, is Section 97, subsection 1 good law? Let's find out.
Thank you, Divya, for the brief introduction. Greetings, my name is Basil, and I will be speaking about the reasonable grounds for Section 97, subsection 1 of the Child Act 2001. Now, before that, it is important to understand the purpose of the Child Act 2001 and how it guarantees that the children's rights are respected in line with global agreements and emphasizes rehabilitation for juvenile offenders instead of punishment. Now, ultimately, the Act seeks to establish a more secure and supportive atmosphere for every child, safeguarding their rights and fostering their growth. Now, coming back to Section 97, subsection 1, it arises in cases where a child is convicted of serious and grave crimes like murder, attempted murder, homicide, arson, excessive substance abuse, and many more. Therefore, the court will then take into account Section 97, subsection A, subsection 1, in order to spare the child from receiving the death penalty. Its sole purpose is to allow for the replacement of capital punishment with an alternative sentence for minors committing a crime that is subject to the death penalty, the harsh death penalty. Now, it was applied and illustrated well in the landmark case of a public prosecutor against Wah Kwan in 2008, where a child who was 12 years and 9 months old of the alleged offense during the event, was convicted of murdering his tuition teacher's daughter. Now, the child was then instructed to be held at the discretion of the Yang di-Pertuan Agong under Section 97, subsection 2 of the Child Act 2001. Now, this section, Section 97, subsection 2, states that the child could be held in custody at the Yang di-Pertuan Agong's discretion if the crime occurred in Kuala Lumpur or Labuan Federal Territory, or under the state's ruler, or Yang di Pertua Negeri if it happened in the state. Now, another instance of the application was shown in the public prosecutor against Muhammad Adli Shah bin Muhammad Yusri in 2021, where the accused, who was 16 years old during the event, was accused of 23 murder charges of the Tahfiz Darul Quran Ittifaqiyah school arson incident. Now, it was held that the accused was then detained in prison at the pleasure of the Yang di-Pertuan Agong under Section 97, subsection 2 as well. Now, many other similar cases have illustrated the implementation of the said section, such as public prosecutor against Ramaya and another appeal, and public prosecutor against Vania Osman, and both cases were assisted by the interpretation of Section 97, subsection 1. Now, many would argue or voice out personal opinions and views toward Section 97, subsection 1, questioning whether it is a reasonable law or just an excuse for a smooth avoidance of the harsh and merciless punishment, just to get away from from being accountable for their own actions, of their own consequences of their action. Now, therefore, should the Section 97, subsection 1 be amended? Various articles suggest that and highlights the importance of this section in preserving life and educating them on the importance of taking responsibility and being held accountable for their own actions when they engage in serious criminal activities. Now, it promotes second chances. And in this case, children often make unlawful, regretful, reckless decisions. Now, this whole act, especially Section 97, subsection 1, aims to protect and prevent any further injuries or merciless death of a child below 18 years of age. Now, my roommate Yasmin will now take over and further elaborate regarding this section with her own points. Thank you.
Thank you, Basil. Hi, my name is Yasmin, and I'm just going to take a step back and talk about the international perspective on the Section 97, subsection 1 of the Child Act 2001. And I'm also going to try to suggest ways in which we can strengthen the law and suggest whether it's good law or bad law in itself. And basically, this section is regarded as good law because it acknowledges children are still developing and do not possess the same level of culpability as adults. Their brains are still developing. For instance, the Supreme Court case Roper versus Simonson. The court itself said that the children are less susceptible to deterrence than adults, meaning harsh punishment won't necessarily stop them from future mistakes. The idea isn't limited to just one country. International standards like the United Nations Convention on the Right of Child echo the principle in Article 37A, and it outright bans the capital punishment and life sentence for minors. Why? Because the focus on them is rehabilitation. We know that children can learn and grow and become positive members of the society. And Section 97, subsection 1 reflects the global commitment by prioritizing restorative justice, helping children heal and move forward instead of simply punishing them. Simply put, the court acknowledged that because young people are still maturing, they should not be held the same standards of responsibility as adults. Their decision-making, skills, emotional control, and overall development are still evolving as they grow up. What we see here is a global consensus that the juvenile justice system should be focused on rehabilitation rather than retribution. The UNCRC advocates for an approach that helps children learn, grow, and become productive members of the society. This approach is based on the understanding that a young person's character is still developing and their criminal behavior is often a result of immaturity and poor decision-making. In contrast, while severe punishments might be deemed appropriate for some adults who have committed heinous crimes, they're never just for juveniles. Adolescents are still in a phase of growth and change, and their actions are still influenced by factors like environmental conditions, peer pressure, and emotional instability. By emphasizing restorative justice over retribution, such as Section 97 supports the idea that young offenders should be given the chance for rehabilitation rather than facing heinous or harsh penalties. While Section 97 protects children from capital punishment, it can be even more effective by tackling the root cause of delinquency. The law can mandate a deeper look into a child's background, including factors like poverty, lack of education, exposure to violence, and even technological or school influences. The comprehensive social assessment would help tailor interventions, prioritizing rehabilitation over punishment. Court cases like Public Prosecutor versus Muhammad Fairuz already recognize the importance of considering a child's circumstances when determining punishment. Rehabilitation support systems, including mental health services, education programs, and family assistance, can help address these underlying issues and prevent future offenses. By prioritizing root causes investigation before sentencing, the court can create a more effective juvenile justice system, examining the child's environment a fully dynamic.
My name is Hannah, and I will further back this up with article findings and also emphasize more on the judge's views. Now, there have been clear commitments of the judiciary's approach in upholding the rights of the child offenders, whereby the application of the section has actually resulted in a significant reduction in the number of severe sentences imposed on minors, reflecting Malaysia's progressive improvement of rehabilitation rather than punitive justice for the young offenders. However, there have been a number of differing as well as consistent opinions on Section 97, subsection 1 of the Child Act 2001. And among the different sources, it illustrates an intricate balance of agreement and difference in this particular part of the law. In the eyes of Ranita Hussein, she stated that the Section 97, subsection 1 aligns with the Convention of the Rights of the Children, which is the CRC, by prohibiting capital punishment for individuals under 18 years old, underscoring a shared commitment to the rights and rehabilitative justice. However, it has been pointed out that the subsequent section, particularly Section 97, subsection 2, raised constitutional concerns by allowing the executive branch, specifically in this case the Yang Ketua Agong, to be granted sentencing authority. This arrangement is seen as contravening to the doctrine of separation of powers. The power granted to the executive branch under Section 97, subsection 2 actually disrupts the consistency and uniformity of the sentencing. It creates a situation where judicially determined sentences can be altered and overridden by the executive decisions, leading to the potential arbitrary outcomes and lack of legal certainty. The need for legislative clarity continues in Tan Sri Dr. Abdul Aziz Abdul Rahman's commentary, which also addresses the judicial contention revolving around the Section 97, subsection 2 of the Child Act 2001. He continues to criticize the potential violation of the separation of powers, adding that the Court of Appeal's decisions to invalidate this section reflects ongoing tensions between the judicial independence and also the legislative intent. Since Section 97, subsection 1 allows for the judicial direction in sentencing juveniles, the CRIN, which is the Child Rights International Network, expressed gratitude upon this section as it respects judicial independence and supports a more individualized approach to the juvenile justice due to its alignment in international standards that emphasize rehabilitation and the best interests of the child. This is deemed consistent with the principles of the CRC, again. Overall, they saw Section 97, subsection 1 as a positive aspect of the legislation that better protects children's rights and promotes their reintegration into the society. Again, the CRIN viewed Section 97, subsection 1 of the Child Act 2001 more favorable compared to the Section 97, subsection 2, similar to the opinions of Ranita Hussein and Tan Sri Dr. Abdul Aziz Abdul Rahman. Furthermore, the Malaysian Bar has voiced out concerns about Section 97, subsection 1, highlighting the necessity of the legislative changes to guarantee clarity and compliance with established legal standards. They pointed out, although the prohibition of the death penalty for juvenile offenders is a step in the right direction, the Section 97, subsection 2 that goes along with it compromises the judicial independence by giving executive branches the power for sentencing. The concept of separation of powers may be compromised due to the interference of the governing body, which could result in arbitrary and inconsistent judgments. To maintain judicial integrity and safeguard the rights of the juvenile offenders, the Malaysian Bar has actually called and demand that these rules be reviewed and amended.
Hi, my name is Carmen, and I am now going to talk about the downfalls of that particular act. Contrary to what my group mates have stated in their respective parts, I beg to differ that Section 97, subsection 1 of the Child Act 2001 is to be considered good law. The reason that my opinion differs is due to the fact that despite the accused being a child, it does not sit right that because the wrongdoer is underage that the consequence should not be as dire as it would be to a person of age. Heinous crimes have been committed and therefore befitting punishment should be delivered as such to those who commit them. A case that I would like to cite is the case of Public Prosecutor against KK 2003, where the Court of Appeal has freed a teenager who was detained in prison at the pleasure of the King, Yang di-Pertuan Agong, for the murder of his tuition teacher's daughter back in 2002. According to the newspaper The Star, the facts are as stated. It dates back to May 30th, 2002, where an international school teacher returns home to find her 11-year-old daughter sprawled in a pool of her own blood at their house in Setapak. The mother immediately rushed her unconscious daughter to the ER, but was unfortunately pronounced dead upon arrival. The last person seen with her daughter was her 13-year-old tuition student who arrived early at her house for tuition. Whilst waiting, the boy was taunted by the victim who called him names and an argument arose between the two. The boy suddenly snapped and attacked the victim with a sharp weapon, resulting in her unfortunate death. Post-mortem then revealed that the deceased died to massive blood loss from 4 slash wounds and a total of 20 stab wounds. The boy then left the scene and returned home, telling his uncle, who picked him up that day from tuition, that his tuition was suddenly cancelled. Although it is clear that the boy was indeed a child when the incident occurred, it does not change the outcome of what happened. Moreover, the shocking part was how the boy actually managed to scheme an excuse, saying that the tuition was cancelled. We define a child as innocent and not cunning. Therefore, his or her innocence is what makes them a child. But in this case, the definition of what a child is seemed to differ from that definition. The violent acts the victim had to endure were nothing short of horrific, gruesome, and cruel even. This grave crime is punishable by death in Malaysia, but as the boy was a child, instead the boy was sentenced to imprisonment as construed by Section 97 of the Child Act. In lieu of a sentence of death, the court shall order a person convicted of an offence to be detained in a prison during the pleasure of the Yang di-Pertuan Agong if the offence was committed in the Federal Territory of Kuala Lumpur or the Federal Territory of Labuan, or the ruler of the Yang di-Pertuan Negeri if the offence was committed in the state. Malaysia, however, do not sentence children to death as we know it. The death penalty is not something that should be taken lightly, as it is a life that is being taken. In my point of view, I do agree with my group mates that a life should not be taken, especially when it was not intentional, as accidents do happen. But I do believe that punishments should be carried out to reform the wrongdoers, as light sentences would not be sufficient remedies, especially to those who have lost a loved one because of another's crimes. Relating back to the case of Public Prosecutor against KK 2003. Thank you, that is all from me.
Hello, my name is Danya and I will be concluding this video. To conclude, Section 97, subsection 1 of the Child Act 2001 serves as the key in the protection and rehabilitation of juvenile offenders in Malaysia. It is crucial to ensuring that children who commit serious crimes are spared from capital punishment, reflecting a more humane approach that favors rehabilitation. This was evident in landmark cases mentioned by Basil, where juvenile offenders were detained instead of facing the death penalty. From an international perspective, Section 97, subsection 1 aligns with the global standards like the UN Convention of the Rights of the Child It underscores the importance of rehabilitation and acknowledges that in children have the potential to reform and reintegrate into society. To further strengthen this law, we could consider incorporating the root causes of these crimes, such as socioeconomic factors, and providing support systems for such children. Various legal experts and organizations, including the Malaysian Bar and the Child's Right International Network, both support Section 97, subsection 1, while raising concerns about Section 97, subsection 2. Both advocate for the legislative clarity to ensure the separation of power of the judicial and the executive and maintain judicial independence within sentencing. However, the concern of leniency of Section 97, subsection 1 highlights the need for a balanced approach. Such cases mentioned by Carmen exemplifies the complexities involved in juvenile sentencing, emphasizing the necessity of considering both the nature of the crime and the comprehension of the crime of the offender. In sum, Section 97, subsection 1 of the Child Act 2001 represent a progressive and compassionate approach to juvenile justice. While it is essential to recognize the severity of crimes committed by minors, this provision ensures that the legal system addresses these offenses with a focus on the potential for growth and change inherent in every child, ultimately fostering a more and just society for all children. Thank you.